So, good morning and welcome to the October session of the Daring to Learn webinar series. My name is Elena Boyd. I am an extension specialist with the UT Center for Profitable Agriculture. We are a department in UT Extension. And if you are new to the Daring to Learn webinar series, welcome. This is a monthly webinar put on by the center on the second Tuesday of every month. Our topics change from month to month, and today I have with us an extension specialist with the University of Maryland. His name is Mr. Paul Goeringer. He's going to be talking with us about succession planning mistakes and how to prevent those in the future. So just a couple of things, housekeeping items before I hand things over to Paul. If you have been on a Daring to Learn webinar session before, you guys know the drill. This is being recorded and will be uploaded to the center's YouTube channel after we wrap up today. There is going to be a QR code at the end of the webinar today. That's going to be your evaluation form. That's a chance for you to give feedback on this session and to provide any other helpful information that you may have about Daring to Learn or specifically about this month's topic. If you are a Tennessee producer and you're looking for that educational credit for the Tennessee Ag Enhancement Program, we do offer an educational credit for that application B, the producer diversification application of TAEP. So if you watch 5 of these Daring to Learn sessions throughout the year and fill out 5 of those evaluation forms, then you will qualify for that educational credit. So keep that in mind if you need that and catch that evaluation form at the end of this session. I will go ahead and, well, if my slide will move, I will give Paul a chance to kind of introduce himself and talk a little bit about his background, and then I'll go ahead and hand it over to him. And if you have sessions or slides in your slideshow that kind of cover this, then I can stop screen sharing. Otherwise, you are more than welcome to briefly give us an intro.
Hi, I'm Paul, and I'm an extension specialist and principal faculty specialist. I'm in the Ag and Resource Economics department, and I'm our statewide legal specialist for the state. And I've been here for the past 14 years and do a lot of farm succession stuff, and just started on the board back in July with the International Farm Transition Network. So I think that's a good overview of Paul.
Okay. I will go ahead and
everything else is on the screen.
I will stop my screen share then.
I will go ahead and share mine, and hopefully you are seeing my slides and not the presenter view.
Yes, we can see them.
Okay. So we're going to talk today, and I have 2 case studies depending on how far we get, and you guys can put answers in the chat and we can kind of talk about some of the things that would come up. But this is learning from others' mistakes and succession planning. And how I go about pulling this together is I start looking at court cases where we have farm succession stuff, where people have taken their families to court later, and start using those to kind of help guide some of the discussions. And as a university extension person, I need to remind people that university programs are open to all, and I need to stop sharing my screen for a second because Paul forgot to check a box for later when we're actually watching a video.
And one other housekeeping thing I will mention, guys, I forgot to do this just a second ago while he's taking care of that. If you have any questions as we move through this session, you can pop those in the chat box. There's also an option for you to like raise your hand, or if you have a question where you think it would be easier to kind of ask that verbally, I can unmute your microphone and give you a chance to ask that.
Hey, it did it this time and it worked perfectly.
Awesome.
Okay. So yes, university programs are open to all.
This institution is an equal opportunity provider.
Now done all my requirements under federal law. I'm also with our university's Ag Law Education Initiative. We have resources on umagglaw.org. The last slide you don't care about because you're not a taxpayer in Maryland to know where the money was coming from. And then this presentation is being funded through a grant I got through the Northeast Risk Management Education Center, where we're working on doing some farm succession workshops for the next year. So I'm going to give a quick introduction to this. And this is the part where I have to remind Elena to pause the recording so her recording does not get clipped.
Got it.
And
Gotcha. It should be recording now.
cool. And I will provide a link to that so you can add it in. So as I often start these off when we're thinking about this, how many people, often kind of feel like Ron when they're starting to think about succession planning? You don't have to put in the chat, but my guess is a lot of people feel like that. We're going to talk a lot about wrong estate plans today, but think about it for a second. What's wrong with his estate plan? If you're not familiar with the character from Parks and Rec, by that point he's recently married, apparently very wealthy from buying gold for years and burying it in his backyard. He has one son and two stepdaughters. There's a lot of things he does wrong in the initial estate plan with not thinking about, his family, other things. We'll talk about some of the other tools here in a minute and then get into the case studies. But there are other things he didn't do well in this either. He didn't think about healthcare directives, powers of attorney, living wills, things we would expect folks in this situation walking into an attorney's office to deal with. What could Ron do better? As we're going to go through the examples, even with the families we're going to look at today, everyone could always do something better in this whole process, thinking about how to deal with certain situations and how to build upon it in a way that we set up a plan that will work. And, as we go through all of these today, think about, if you were in the people's shoes, how would you handle that situation, knowing as we go through some of the case studies, what the outcomes can be. So as I often like to point people out on this, today is about getting you to where you want to go in this process. As I point out to everybody in succession planning workshops, our goal is really just to help you figure out kind of some of the tools you want to use and how to get you to a spot where you want to go. At some point, as much as you may not want to, you're going to have a communicate to your family on what these decisions are. And who in here wants to have a discussion with their family on, death issues? Not many of us probably want to have that. If we're children, we probably don't want to have that with our parents. And if we're parents, we probably don't want to have that conversation with our children. But it's ways, things we have to think about and do. And this is one plug I'll make for the International Farm Transition Network. One of the things they do really well is helping train people that can go out and help in these situations, sort of help aid in the conversations with folks. And if you go to their website, there's a list of folks that are trained in Tennessee and other states that may be able to help with this. And then at the same time, by the end, it's start thinking about maybe there has to be a business plan formed in all this to help whatever the farm's going to look like later. And at the same time, have an estate plan developed in a way that we can keep, the operation going or distribute the assets depending on what's going to happen to that farm later. So what happens if you communicate your plan? You can take a minute, read this. A friend of mine in Iowa, who's an attorney and does a lot of farm succession work, sent this to me and another group one day, just saying, hey, we talk to people all the time about communicating. This guy clearly communicated his plan. And if you don't want to read all of it, he had a plan or has a plan. His plan is to have his skull, his body turned into 2 gems, his skull taken, put on the mantle with the 2 gems as eyes, and that just set up there for years. And his wife sort of tells him all the problems with said plan. But he doesn't want to listen to any of that. He really thinks this is a good idea. In this whole process, we're probably going to come up with ideas we think are really good. We really need to listen to others because there may be huge problems with this. For those of you that don't know, most of what he wants to do might be illegal in most states in the country. And eventually the skull will be discharged and people will have 2 gems and they won't know where they came from. So we're going to have ideas. We need to listen to others. We need to take into account other people may have better solutions for us that may actually work and get us to where we want to go in the long run. So let's go back to Ron at the start. Ron doesn't have a plan. He has a piece of paper with something written on it. That document's not a valid will, really, in any state. Someone that kills you cannot actively participate in your estate plan. And we really don't leave items to animals. So this is kind of hard to deal with. But one of the things they keep pointing out in that clip is if you die without an estate plan, everything's going to go to the state. That is not true. In all states, if you die without an estate plan, you die in what is considered intestate. And your estate is governed by the state laws where your property is. So for the most part, it's where you're domiciled at the time. Real property outside that state becomes an issue because we may actually have to follow the real property laws in the state where the property was located. But for the most part, everything, if we're all just in one state, it's going to be distributed according to the state laws of the state we were living in. The idea is, in the end, your property is going to be divided up among your family members. If you're married and have children, typically about 50% will go to your surviving spouse, and the other 50% will go to your children, or if your children are predeceasing you, it'll go to their heirs, their children. If you're not married, don't have children, it may go to your parents and then part to your brother and sisters if you have siblings, or it may go to other family members. Typically, it's going to go to family members. It's never going to go to the state unless we can never clearly find somebody in your family tree that could take the inheritance. The thing to point out in all this is we don't care about your relationship with your family in this process. We often have to remind people, potentially if they're going through divorce or something else, they're not communicating with children, that child, that spouse that they may be divorcing may still take an intestate situation because the law doesn't care. The law just looks at what the relationship was. They don't care about were you actually talking to them, were you in the process of a divorce or anything. So really, in a lot of these situations, we start telling people, hey, you really need to start, thinking about this and doing this. And there's been a number of cases over the years where people have died without wills, and we have to deal with the issue of divorce or something else. And you may wonder why I have Snoop Dogg and Snoop Dogg's family up there. Snoop Dogg, about 10 years ago, said he didn't want to have an estate plan. He wanted to be reincarnated as a butterfly and watch his family fight over his fortune. You can Google this. He actually did say this. Yeah, there's still a plan, even in that situation, where there's probably going to be minimal fighting in the end. And if folks have questions, you can put them in the chat. So we get to the point where you want to develop an estate plan. First thing, when Ron finally gets to that point, is he talks about at some point about who the guardian for his minor children will be. Might be a man and his wife in their 90s, but they have a backup plan to that. You'll often go in and have backup plans for folks you're going to put in your will to do certain things just in case they can't do it or situations change and they're just unable to at that point. So we're always going to think about, if we have minor children, who's that guardian going to be if something happens to us? We're going to designate certain beneficiaries that we can for property in that estate plan. We may have already done that outside of a will through life insurance and other things, but we're going to set up who will get certain items within that. We're going to set up powers of attorney, and they'll have different names, but they're both more or less powers of attorney. We'll set up a power of attorney for business, or people can make business decisions for us. They can still continue to pay bills along the way. We'll do a healthcare proxy, power of attorney for your healthcare, where that person is making healthcare decisions for you when you can't do that. And in the case studies, we'll talk about a common mistake a lot of families make in this situation when it comes to healthcare directives. I'm not going to give away the common mistake yet. We can talk about it when we get there. We'll put together an advanced healthcare directive as well. These are also known as living wills. They discuss when you want life-sustaining procedures done to you. Do you want to be resuscitated at certain points? Do you want to be left on life support? As I tell everybody, they are the most depressing document you will ever read. And typically they're that way because the statute laid out what they had to say, and the form you work off of follows the same process. And it literally is checking boxes in a lot of cases as to what you're willing to take and what you're not willing to take in that situation. And as I often point out to people, why are we doing advanced healthcare directives at this point? Who is the best person to tell people what you want in certain situations? Your children, other family members, or you? Most of us will probably say ourselves would know better what we want compared to other people. So we're doing this to take the pressure off family members later when it may be a very stressful situation for them to have to think about what you would want in those cases. As a part of this, we'll do a will. We may or may not do a trust depending on situations. We may have life insurance associated with this. We'll talk about why we might want to do life insurance earlier on as we're setting up with the case studies and how that can help in some of these situations. Other tools we might want to think about that can somewhat make this easier to do too. We may want to have business entities where we can just pass along the ownership of the farm through the business entity to make it easier to pass it on to the next generation. We can use LLCs or corporations for that in a way, and USDA has made that a little bit easier to use to meet some of the program payment limitations that are in federal law right now. We'll talk about long-term leases where if we're going to have, a non-farming heir take over property that's currently being used in the farm, should we have long-term leases set up with rights of first refusal if it goes up for sale? And what are some common problems with that? All this will depend on your goals. One of the biggest things we always talk to folks about in this is, do some goal setting before you come in. And that will really help the process with the attorney. So what are some other possible tools that we hadn't talked about? One, life insurance. This is all going to pass outside the will because you've already selected the beneficiary on the policy. Payable on death accounts, bank accounts, you've already selected who that goes to. I often point out, I really have an estate plan. I don't have a will. A lot of the stuff I have set up is either payable on death to my parents, or if they're not here, my brother and sister can have it. Joint bank accounts, if we're married or have a business partner or something where we have that joint bank account, that's already set up in a way where we don't have to do this. Real property that's held as joint tenants with rights of survivorship, we've already set up in that title document who gets it next, because it continues on with the joint tenants until one is left. And then that one person gets it in fee simple absolute. Okay. Couple of things to think about in all this. The will is the legal document that expresses the person's final wishes. Typically, it's going to lay out who the executor is. That's the person who's going to carry out the final instructions in the will and make sure everything's done. It's going to designate who the beneficiaries are, those taking under the will. The other tool we might use is a trust. And we use these in a lot of situations. Trust, it's just an estate planning tool. As I point out, it's not always for everybody. In a lot of cases, we may consider it when we really are getting close to those federal estate tax limitations, because there's ways to set it up within the trust so we can avoid some estate taxes. For this year, it's 13.99 million for an individual. It's 27.98 million for a couple. So we may look at it then if we're getting close to those estate tax limitations. For next year, it's 15 million. It goes up based on inflation each year, and IRS releases it about around Thanksgiving time each year, what that new limit's going to be. We may look at it if we have children who are minors or disabled family members, to be able to provide for their care if parents pass away unexpectedly. If we have a child who's disabled, and we'll know they'll be disabled and need care throughout their life, this is one way to take care of them. We can also have it set up, which is what a lot of people do. They set up living trusts. That's just a form of a trust. So it's easier to manage their own affairs if they become unable to. Then we can manage business decisions and decisions like that through the trust. We don't really need a power of attorney at that point, other than for the individual, but for the property and a lot of the other stuff, we're managing it through that trust. We can have a testamentary trust where we just create it in the will. We typically do this for minor children or disabled family member if we haven't taken care of that earlier before the will and gotten that set up. Living trust are what most people are using a lot in estate planning these days. The idea is you create this during your life and it continues after your death. And there's some IRS rules as to when they need to be extinguished and property needs to be distributed. They are revocable throughout the course of your life if you are the person that sets them up. You can make any decision and change it as much as you want to up until the point you pass away. At that point, it becomes irrevocable and it's permanent, and there's really no power to change it. We just kind of distribute the assets according to the terms of the trust, and the trust just basically goes away once it's extinguished. People consider this really to avoid probate costs. Probate costs money in each state. I don't know what the cost is in Tennessee, but it's usually a percentage, 1 to 2% of the estate in the end is paid to cover probate costs. There's typically attorney's costs associated with that too, because you'll have an attorney helping you walk it through. If we have property in multiple states, it just allows for easier transfer because we can deal with it through the terms of the trust. If we're not doing it through that and we're going through a will, we have to probate the will in each state where you owned real property. We, like I said before, can manage assets if you become incapacitated, and typically we can distribute property to the beneficiaries faster than the probate process. Probate can take 1 to 2 years, depending on backlog in the state and if anybody files, any objections to the will throughout that process. That's typically pretty rare, but it can happen. They're expensive to set up and update at times. Some of the reasons people don't look at them. We're going to require an attorney to draft this. We're also going to need an attorney to draft the will. And for some, the expenses can outweigh the benefits. So why do people go with wills and why do people go with living trusts? Well, you can see my pros on the side. You get control of the property till death. You can direct who gets the property. You get to select who the executor is and who the guardians are. And once the property is distributed, it goes away. You have to probate it is a con. Probate's a very public process. Your will's put in the public record. Everyone in your community can know how it goes. I often ask this question: how many people have ever gone to the courthouse and looked at a will? Not many people have done that. They can be contested even with no contest clauses added in, because there are reasons why we still let you contest a will even with a no contest clause. And a no contest clause typically says if anybody that is a beneficiary under the will contests the will, they lose out on their share. Like I said, it takes time. It's a public process. And it's very state specific. If we're having property in multiple states, we got to have it good to go in multiple states. Pros and cons of living trusts: we get out of probate. It's not public information anymore. It's very difficult to contest. You have to be a beneficiary in the trust to be able to contest it. If we got minor children, we already have a trust set up to hold those assets for the minor. We can keep that going. We'll potentially have trustee fees. Typically, you may not. If you have a child doing it and they waive the ability to collect fees, you don't have to pay that. Typically, while you're alive and managing it, you're not paying fees. But if somebody like a financial institution gets involved or an attorney, they're probably going to collect fees. It adds some complexity to asset management. We have to remember stuff is in the trust and not in our own name and deal with it. We still need to coordinate it with other estate planning tools. And oh yeah, you still need a will. Even if you do a trust, you still need a will, because at some point you will forget to title something in the name of the trust and you'll need a document to do it. We call those pour over wills. They're really simple wills. They basically say, I might have forgot to put something in my trust. Just distribute all the assets that would not that fall under this will according to the terms of my trust. We have about 20 minutes left, so let's look at some case studies. And I am going to stop sharing my screen there. And then hopefully, if I go to everyone, and hopefully the first case study distributed into the chat box for everybody. If it didn't, let me know.
It did. I can see it.
Perfect. And now I will make this bigger on my screen. And hopefully you're seeing it on the screen now too. So go ahead, read through to the first set of questions. I'll give everybody a minute and a half to read what I wrote out. And I'll point out to everybody, this is a real case, and I changed the names and the locations to protect the innocent. Okay. And you can put this in the chat or raise your hand if you feel brave enough to speak up in public. You know, what issues do you see developing with their, estate plan? David and Alice, mom and dad. Get the chat open so I can see. Well, you might be getting brave to type in. I'll start talking. What about making both of their children share the powers with the durable power of attorney and the healthcare proxy? Is that a good idea? Well, I'll start typing in as I start talking. Typically, in this process, if you're working with an attorney, they will probably attempt to get you away from this process of sharing those powers between two children. We may have it between two, just so there's one there as a primary and one as a backup if they're not there, and we can set it up that way. But, typically, do we want that? No, that just makes some of the issues we have to deal with harder. Not so much from the attorney standpoint, but from the children and family standpoint. As I often point out, if people in here have children, how often do they agree on anything? And how often might they fight?
Almost never and often.
And often. And now we're dealing with people trying to make business decisions and your healthcare decisions for you. And we have to get them all to agree if they are the healthcare parts, or at least a majority of them to agree. In this case, we would need both of them to agree because we would have no way to get, a clear majority of people supporting a decision. What happens if they don't speak to each other? This just creates more problems too. So we often don't know the family dynamic here. It gets worse as we go along, but we don't know what it is before it gets worse. So this may be a problem down the road that they have to deal with this. And I've seen families have to deal with that over time, that it really does create issues. If one child is really slow at responding and we really need to make a decision because mom or dad's health care relies upon the decision being made while we're with the doctor and getting something done that day, we may not be able to if they're incapacitated and can't deal with some of these situations in certain cases. From the estate planning process, they've done what most people would do. They've equally divided the farmland up and really have set up in a way to where the one son who's remaining on the farm, Tony, can continue to farm it and have David inherit part of it. So he still gets part of what the family has accumulated over the time. He'll get, 350 acres. David will get, or Tony will get 350 acres. So that probably is not that bad. Does Tony have protections to ensure he can maintain the property? He does have some protections. At the same time, he's grown his own farming operation, so we may not have other issues later. Based on how it's set up, could Jeff force a sale of his portion of the farmland later? Yes, he could. He could decide to sell it. David could decide, he wants to buy it, take out a loan to buy the farmland, or, and do that. I work with a person who also does this at another university, and one of the discussions we've often had at many points when it comes to question 3 is, does it make any sense ever in a business operation to buy the same asset twice? In theory, we're forcing Tony to buy the same asset that his parents already bought, and at substantially higher prices than they probably paid for it when they originally bought it. Is there anything you would do differently? And we may only get through one case study today. But I sent them
So
both to Elena if she wants to send them out to y'all later.
yes, yeah, I can share those with you guys when we finish up. One, I guess, question that I would ask related to this, because I think this is something that um, we see fairly often. So in this situation, like with the two children, one of them is on the farm and the other is not. Is that common for the healthcare proxies to be set up that way? Though that way both adult children would make that decision, especially since one of the adult children is not involved or there.
It is pretty common. Parents will often go in and say, well, I want all my children to be treated fairly in this and make them all decision makers in it, not thinking about and not wanting to listen to when they're being told this is a horrible decision. Even though I'm being recorded and my parents might find this on YouTube later, I don't care. My mom's family made this decision, and she has three sisters plus her, and they all four had to like agree on stuff. And it was really hard with a few of them who might not always respond to phone calls quickly to make decisions, when my mom and one of my aunts were the closest that would help take care of grandma. So it's pretty common that parents do that. They don't want to show favoritism to one child.
Mhm.
No parent loves one child more than the other. As a child that's not that loved by my parents, I disagree with it. But yeah, it is pretty common with the healthcare proxies to do that.
Okay.
And anything done differently, I will say the long-term lease situation is fairly common too. We will see farmland set up in that way to where half of it's going to go to another party, and or half to one sibling and half to another, with long-term leases and first rights of refusal. That is 100% pretty common in this area that we would see set up. So now I'll let you finish reading the last little bit and we can get to the last set of questions, and then you guys can ask me questions at the end. I'll leave about 5 minutes for questions. I should have went with the dairy example. It would have been more fun, but I grabbed this one first. And if I said this is 100% a court case, everything that is in here is, I did not embellish anything that was not in the court's facts of the case. Okay. Hopefully I've given everybody enough time to read. So as we talked about, there are issues that started developing with our healthcare proxies, isn't there? It's really hard at that point for the one that is there to make the decisions and help get her the treatment she needs near the end. Mainly because if you're the child that's not there and seeing it every day, what might you think? Oh, mom just has memory lapses like everybody does. You're not experiencing it full time and know how bad it is. So these issues can come up. Is there anything Tony can really do to improve his mom's health care at this point? Not so much. She probably is in no condition that she could go back into an attorney's office and update any of her healthcare directives. One thing we didn't talk about throughout all this, but now is a good time to talk about, is in almost all of these, you have to have capacity to be able to sign these legal documents. And if you're a person that's in Alice's situation and you walk into an attorney's office with your son helping you get there and everything, which we would expect for an older person, we're probably going to kick Tony out of the room because we want to verify that she has capacity on her own. And capacity just means I have the ability to tell you certain things like what day of the week it is, who my children are, who the president is, certain things that we can say, oh, this person is, functioning. And more than likely, the parent who's being brought in at this age will be put on camera because we will want every bit of proof later that nobody was in the room, nobody was telling them the answer. And the reason we're going to kick Tony out of the room is if you're the parent, if you're the child, what is your first instinct to do if your parent struggles or anyone struggles to answer a question? Are you going to attempt to help them? Or are you going to let them fail? So we're going to end up with a lot of issues where they're potentially going to have fail. So we're going to get them out. So what decisions could they have made earlier on about this? They could have looked at the situation and went, Tony's the one here. We're going to put Tony in charge. We're not going to work, we're going to encourage him to work with Jeff in these processes and get them to where they can at least talk and communicate when things happen, which does happen, and make sure that's being dealt with. One thing we didn't deal with in the questions up earlier is, and I'll scroll back up, is if Jeff were to force a sale of the farmland, would Tony want to buy the farmland? What's the one detail I gave you in the whole situation as to how old Tony is at this point? Tony's 50. Does Tony want to take on the debt of buying 350 acres of farmland? Depending on what the price is in the state he's living in. I put it in Maryland, so prices would probably be fairly consistent with other parts of the country, not Iowa or Illinois, but fairly consistent with other farmland prices. So would Tony actually want to do that or just let it sell? We don't know the answer to that question because Tony may actually want to retire at some point and may not want to take that debt on at 50 years old. And I'm going to stop sharing my screen if I can click that button. What questions do folks have?
So in that situation, I think this kind of ties back into the question that I asked earlier. So in this situation with one child being away, the other being there at home, but with the way that that healthcare proxy was set up, it's both of them have to make the decision or nothing, basically.
Yeah, both have to make a decision. There's one more, we could have got two of them to agree and cut out the other one. Again, I'm being recorded and don't care if my parents see this. As I freely, I think I've told them multiple times, I am the child living 20 hours away in Maryland. My brother lives a mile from them. I'm probably not the one to put in charge of healthcare because I'm just not there on a daily basis. I'm also probably not the one to put in charge of business decisions either, just because I'm not there on a daily basis. He is.
Well, for those of you all who are with us, if any of you guys have questions, even if you would rather kind of ask those verbally, we have time to do that. Feel free to ask those, either related to the case study or some of the things that we mentioned earlier in the slides. Let's see.
Oh, I put if anybody wants to read the second case study later, it's there for you to read.
Gotcha. Awesome. Thank you. So both of those case study files are in the chat box. I will include those in the follow-up email for this session also that you guys will get once we wrap up. So you'll have both of those in a copy of the slides as well. And while you guys are thinking on any questions, I'll go ahead and pull back up that QR code we talked about.
Yes.
So, just as a reminder for our Tennessee producers, if you're looking for that Tennessee Ag Enhancement Program educational credit, filling out this evaluation form will get you one of the 5 credits that you need to qualify for that. This is also a chance for you guys to share any feedback at all. If you have any other questions, we'll hang out for just a few more minutes. Feel free to pop those into the chat, or if you have any, once I get that follow-up email out to you guys, I can pass those back on to Paul. And looks like you did
I got a
get
question.
one.
Yeah, the biggest advantage to me is always just the ability to, in some cases, avoid probate, but it does allow for, and I'm trying to think of how to word this. It does allow for easier transfer of property and just easier management of property over time. Especially if we're dealing with large farms, even small farms, but it does create disadvantage. And I know here in Maryland, where we have folks that have farmland on the Eastern Shore that may be in Maryland, Delaware, and Virginia, with the ease of just how close the states are together, it does allow for that easy transfer without having to go to multiple states to do probate with some of that. So for me, that's the biggest advantage. Just it does away with probate and a lot of the probate costs that could come up in that process. And the management of the assets if something happens to you, to where we have a lot easier way to manage it through the trust. And we're seeing that a lot more with living trust as people get dementia and Alzheimer's. It just creates that system that we can manage when people have to go into a nursing home.
And for context there, for folks that come back later and watch our YouTube video, that question that we just got in the chat box asked, what do you see as the biggest advantage to having a trust? So we just touched on that.
And one
If,
thing
go ahead, I'm sorry.
I was going to throw in one thing I don't talk a lot on because it's not something I'm really good at, is in a lot of this too. One of the bigger things we have to start thinking about too is just how do we get around Medicare and Medicaid eligibility requirements as we age to make sure we're not eating up farm assets to pay for long-term health care? Or are we younger and purchasing long-term health care insurance, which may have not been available to everybody who's needing it now when they were young, but finding ways to make sure that we're managing it in a way that we stay eligible for healthcare programs that can help us if we have to go to long-term healthcare. And their attorney's really good at that. I'm just not one of them because it's not stuff I did before I got into this.
All right. And if you guys that are still hanging with us, if you have any other questions, feel free to ask those or throw those out here. We'll hang out for just a few more minutes, but I don't have anything else for you guys. I will get the 2 case studies as well as those PowerPoint slides over to you in that follow-up email. And if you have any other questions after we wrap up today, I can pass those along to Paul. But otherwise, if you all don't have anything else, you are free to go and we will wrap up. Thank you so much for sharing all of this information with us. This has been really helpful and a good chance for us to see succession planning from kind of a different angle from some of the other topics that or presentations that we've had earlier this year.
I thought this would be different from what you had in the past.
Yeah, this was nice.
Yeah, no problem. Thank you guys for attending today.